Hello and welcome to the YouTube channel of RankersBuzz. Today we will discuss about another important case from the Honorable Supreme Court. The decision has been pronounced by the Honorable Supreme Court recently. So let's discuss about this case. So the case today that we will be discussing here is the Food Corporation of India versus Abhijit Paul 2022. So today we will discuss about this particular case in which we will talk about the contract which was made between the two parties and the dispute arose. जो dispute उसके बीच में हुआ उसके बारे में बात करेंगे and what has been decided by the Honorable Supreme Court, that also we will discuss. So this case was heard by Justice P.S. Narasimha and Justice A.S. Bopanna. So this was a division bench decision given by these two honorable judges of the Supreme Court. So what is the storyline of this particular case? So in this particular case, FCI has made a contract with suppose XYZ company, and FCI says that it was the duty of XYZ company to load and unload the grains from the train within a time frame. एक टाइम फ्रेम के अंदर इनको लोड अनलोड करना था, ऐसा FCI का कहना है that this was the duty of the XYZ company. But what happens that the railway imposes certain kind of charges. Railway imposed certain charges on the FCI for delay in the loading and unloading of the material. So certain charges was imposed, and therefore the FCI said that it is the XYZ company which is liable to pay all these charges which has been put by the Indian Railways. So यहाँ पे यही था, whether it was there in the contract or not, and whether such charges can be taken from the party from which this FCI has contracted. So let's see what happened in this particular case. So it was an appeal by the FCI, that is Food Corporation of India, against the judgment of Tripura High Court. त्रिपुरा हाई कोर्ट के डिसीजन के खिलाफ यहाँ पे अपील में FCI जाता है सुप्रीम कोर्ट, और त्रिपुरा हाई कोर्ट ने पहले क्या कहा था? इट वाज हेल्ड दैट demurrages cannot be recovered as a charge by the corporation. कहता है कि FCI जो है वो जो demurrages हैं उनको जो है यहाँ पे रिकवर नहीं कर सकता है कॉन्ट्रैक्टिंग पार्टी से. So here what do we understand by this particular term? इसका मतलब क्या है? So it is nothing but these are a kind of charges or charge payable to the owner of the, you know, it is either it is chartered ship or railway, train, or whatever it is, on failure to load or unload, to load or unload the ship or the train विद इन द टाइम फ्रेम. जो टाइम फ्रेम है उसके अंदर नहीं कर पाते हैं तो एक चार्ज जो है वो पे करना पड़ता है बाय दी टू दी ओनर ऑफ द आइदर रेलवे और सो. तो यहाँ पे रेलवे ने इसी तरीके से जो है इनसे, क्योंकि टाइमली नहीं उतार पाए फेलियर टू दे फेल्ड टू लोड और अनलोड द ट्रेन. That is why certain charges was imposed on the corporation, which was further asked by corporation to be paid by the contractor. So this was the situation till now. And तो यहाँ पे हाई कोर्ट ने, जो त्रिपुरा हाई कोर्ट ने कहा था that कॉन्ट्रैक्ट को उन्होंने एग्जामिन किया. हाई कोर्ट की अगर हम बात करें तो हाई कोर्ट एक्चुअली examined this contract, examined the contract, and after examining it said कि भाई the parties did not intend to include liability. कहता है the contract जो है उसे देख के नहीं लगता, it कहता है कि it did not intend to include liability on account of demurrages as part and parcel of the expression charges. तो कहता है the corporation, it is the third party, this company is the contracting party, is not liable to pay such charges because it is not intended in the contract. Contract में ऐसा कहीं पे भी intend नहीं किया गया है. So what is the issue in this case because of which this case came to the Honorable Supreme Court? So let's see what is the issue being raised in this particular case. So in this case, the issue is whether the demurrages imposed on the corporation by the railway can be in turn recovered by the corporation from the contractor as charges recoverable under the contract. So it is whether the demurrages payable to the demurrages imposed on the corporation by the railways can be in turn recovered by the corporation under the contract. क्या कॉन्ट्रैक्ट के अंतर्गत अगर कॉर्पोरेशन चाहे तो क्या वो फर्दर ये जो फाइन इंपोज किया गया, क्या इसको फर्दर जो है वो कॉन्ट्रैक्टिंग पार्टी से क्या रिकवर कर सकती है या नहीं कर सकती है? दिस इज द इशू रेज्ड इन दिस पर्टिकुलर केस. So let's see what the Supreme Court has observed and the decision made. So the court said that the scope of the expression charges, कहता है कि भी जो expression है charges, ये जो charges की बात है, must be understood as intended by parties to the contract. It is all depends upon the intention of the parties while making the contract. The charges, जो यहाँ charges शब्द जो use किया गया है, the charges imposed, the charges to be recovered, this must be understood as per the intention which was there when this contract was made. So the court also examined the expression charges in the context of its related words in the contract. उसने फर्दर इसको जो है और ज्यादा ऑब्जर्व किया और कहा कि भाई charges can be understood as some kind of costs, damages, registration fee, and expenses. इसको इस तरीके से समझा जा सकता है. These can be charges. These expressions indicate the different heads under which losses are recoverable from the contractor for the acts of negligence. अगर वो अपने काम में जो काम उसको दिया गया है, अगर वो उसे नेग्लिजेंटली करता है, अगर ये ऑब्जर्व किया जाता है that he did that act with negligence, ठीक है, if it was done with a negligence, then definitely in these forms it can be recovered. इसको रिकवर किया जा सकता है because of the negligence, अगर ऐसा कुछ होता है. However, it said that these expressions are wide and do not aid in understanding the meaning of the expression charges. कहता है हालांकि ये जो वर्ड्स हैं, ये जो शब्द हैं, ये बहुत ज्यादा वाइड है. अब इसको हम हर कंटेक्स्ट में चार्जेस के लिए यूज नहीं कर सकते. Thus the meaning must be understood in the larger context of the contract. तो मेनली कहता है कि इन वर्ड्स को भी समझने के लिए हमें कॉन्ट्रैक्ट को ही देखना पड़ेगा कि भाई कॉन्ट्रैक्ट किस इंटेंशन के साथ बनाया गया, किस मोटिव के साथ बनाया गया. दिस इज इंपॉर्टेंट टू look. Then court further says that the real question is, जो real question है यहाँ पे वो क्या है. तो कहता है the real question is whether the contractors had an obligation toward loading and unloading of the food grain. सबसे पहली बात तो ये है कि भाई whether the contractor had any obligation, क्या उसकी obligation थी भी, उसकी ड्यूटी थी ऐसी कोई towards loading and unloading food grains from railway wagons. क्या उसकी ऑब्लिगेशन था भी, ये नहीं था, सबसे पहले तो ये चीज देखने की है. सो कोर्ट एग्जामिन्स दिस थिंग फ्रॉम द कॉन्ट्रैक्ट. सो आफ्टर एग्जामिनिंग द कॉन्ट्रैक्ट, कोर्ट कहता है दैट देयर इज नो कॉन्ट्रैक्चुअल प्रोविजन लाइक दिस, कि कोई भी ऐसा कॉन्ट्रैक्चुअल प्रोविजन हमें दिखाई नहीं देता है. नो कॉन्ट्रैक्चुअल प्रोविजन लाइक दिस गिवन इन द कॉन्ट्रैक्ट. कोई ऐसा प्रोविजन है ही नहीं. Further, based on the interpretation of the expression charges in the contractual context, it was opined, court has opined here, that it did not include the liability on account of demurrages. Thus, the corporation cannot impose and collect these kind of charges. तो कहता है जब ऐसा कुछ दिया ही नहीं है, then they cannot collect the same from the contractor. They cannot collect the same from the contractor. जब ऐसा कुछ दिया ही नहीं है कॉन्ट्रैक्ट के अंदर, तो how can you recover such an amount or such charges from the contractor when it is not given in the not given in the contract? And even on face of it, there is no nothing which can suggest that there was an intent to get these kind of charges whenever it will be put by the railways. ऐसा कुछ वहां पे दिखाई नहीं देता. So court, while comparing the present contract with similar but not identical contract, entered the corporation's confirmed that the interpretation of the word charges in the contract is exclusive of liability. तो कहता है अगर हम प्रेजेंट केस की बात करें तो यहाँ पे कहीं पे भी लोड अनलोड की बात कही नहीं गई थी. Thus, the liability of contractor in the present contract is clearly distinguishable. कहता है क्लियरली ये एक अलग तरीके का कॉन्ट्रैक्ट नजर आता है फ्रॉम द अदर कॉन्ट्रैक्ट्स entered into by FCI. FCI जो बाकी कॉन्ट्रैक्ट करता होगा और ये कॉन्ट्रैक्ट करता है, इसमें जो है वो डिफरेंस है on the face of it because it is having a different scope and objective. Therefore, the court upheld. Therefore, the court upheld the decision of the Tripura High Court. त्रिपुरा हाई कोर्ट के डिसीजन को यहाँ पे अपहेल्ड कर दिया गया. सो द बेसिक पॉइंट इन दिस केस वाज कि भाई इट इज ऑलवेज इंपॉर्टेंट टू लुक इनटू द इंटेंशन ऑफ द पार्टीज. You know, when such a contract was made, it will be, you know, checked whether at that point of time, you know, such an intention was there or not, or such kind of, you know, provision or clauses has been included in the contract or not. If it is not included and the intention is not clear on face of it, then definitely you cannot recover such kind of charges arbitrarily from the contractors. So this was all about this particular judgment. So I hope you all have understood this case. This is Food Corporation of India versus Abhijit Paul 2022. So thank you very much, everyone. Thank you for joining. And we will come up with more such judgments